Welcome to The Explainer. Today, we're diving straight into a massive paradigm shift currently unfolding on the Isle of Man, and honestly, it's one that fundamentally changes the entire global data economy. We always hear data called the most valuable asset of the 21st century, right? But despite its absolute dominance in our modern economy, the way we legally treat it is, well, it's surprisingly primitive. We're going to explore how a world-first statutory framework is literally turning data into a formal, legally recognized asset class, and exactly why that matters for every major industry out there.
So start by asking yourself this question. What data assets do you actually own? And I want you to think about this from a strictly legal perspective, not just what's sitting in your company's spreadsheets or internal servers. If I asked you what data your organization holds, you could probably give me an answer pretty quickly. But what do you absolutely own? Own in the exact same way you own a building or a patent or a security. Imagine what would happen if you had to definitively prove that ownership to a lender, a business partner, or worse, a court of law. Which brings us to a pretty staggering realization. There is a simple question that literally no organization in the world can answer with absolute legal certainty. What data assets do we own? The legal infrastructure to answer this definitively, it just doesn't exist anywhere right now. We have massive organizations building their entire futures, their whole business models, on data. Yet, they completely lack the fundamental legal certainty to prove that the foundation they're building on is actually theirs.
If we compare this to traditional physical assets, the contrast is kind of mind-blowing. Traditional assets solved this centuries ago, but the data landscape, it is essentially the Wild West. Think about it. If you buy a plot of land halfway across the world, a total stranger can verify within minutes that you own it, what encumbrances sit on it, and if anyone else has a legitimate claim. You can easily register a ship, you can register a patent. But data? It's like finding a massive gold deposit in your backyard, but realizing the concept of a property deed hasn't been invented yet. There's no register, no title system. There's absolutely no way to independently prove what you hold or who else has a claim to it. 630 billion euros. To put that into perspective, that staggering number represents just the European data economy alone, and it is operating entirely without this foundational governance infrastructure. Every single other major asset class figured this out hundreds of years ago. But the very asset class that's reshaping finance, healthcare, and tech, it's running on a legal framework that is, at best, totally incomplete.
So let's look at Section 1, the governance gap, and specifically information asymmetry.
The core issue here is that we are facing a shortage of governance, not a shortage of data or laws. I mean, sure, we have data protection legislation. We've got intellectual property frameworks, contract law, but none of those collectively provide a comprehensive way to treat data as an actual asset class in its own right. And without a formal registration mechanism, the friction is just immense. This information asymmetry means that if a buyer can't verify what they're acquiring, transactions simply stall out. If a lender can't confirm a dataset even exists or has a stable identity, there is no way they'll accept it as collateral. And for AI developers, man, if they can't prove the provenance and licensing status of their training data, they're looking at regulatory and litigation risks that are literally growing by the month. Moving right along to Section 2, the solution, specifically the Data Asset Register. To solve this massive gap, the Isle of Man is proposing the world's first public register for data assets through their Foundation's Amendment Bill. Built on existing legal frameworks, it's designed to do for data exactly what a land registry does for real estate, or what a securities depository does for financial instruments. Now, it's absolutely vital to note here that this Data Asset Register, or DAR, does not hold the underlying data itself. Okay, it's not a giant hard drive in the Irish Sea. It also doesn't override existing data protection laws. Instead, it creates a single authoritative point of reference for trust and transaction. It meticulously records exactly who holds the asset, what rights and restrictions apply, its provenance, and its classification. And here is where the magic really happens. The DAR is what's known legally as a constitutive register. If you're familiar with how patents work, this flow will feel incredibly natural to you. A patent doesn't legally exist until it's examined and officially entered on the register, right? The register doesn't just provide evidence. The actual act of registration is exactly what legally creates the property right. The DAR follows this exact same logic. Before registration, you just have raw data sitting in an organization. After registration, boom, a legally recognized asset with a fully defined property right is created and vested in a data asset foundation. It's a total game changer. Now, I know what you're thinking. Can you really own data? This is the immediate counterargument. It's usually the very first question people ask, and rightly so.
Data is fundamentally different from a physical ship or a plot of land. Land can't be in two places at once. But data? It can be infinitely copied, shared, and used simultaneously by thousands of people without ever being diminished. In fact, academic literature has argued forcefully for a long time that this exact characteristic makes data totally unsuitable for traditional property treatment. But the legal response to that argument is actually quite elegant. You see, the property right created by this registration does not attach to raw data or abstract facts. Those can't be owned. Third parties are still entirely free to independently compile equivalent datasets from their own public sources. Think of it like copyright. It protects a specific expression of an idea, not the underlying idea itself. Similarly, the property right here attaches only to the uniquely curated, structured, assured, and registered asset. So if two different organizations independently compile similar datasets from public info, they can both register them, and they both hold valid, distinct property rights in their respective registered assets.
Okay, Section 3. Let's talk about the real-world commercial impact of all this. Putting these legal foundations in place doesn't just fix a theoretical problem. It opens up entirely new forms of economic activity. Take financial services, for example. Data-backed finance moves from an interesting concept to an executable transaction. With the title system, you can actually use governed datasets as hard collateral. For AI developers, the DAR can issue official provenance certificates. With the EU AI Act's strict requirements around training data transparency kicking in, being able to provide certified evidence of your AI's training data origins becomes commercially essential to fend off intensifying litigation. And for any data-intensive organization out there, this completely transforms a standard internal data catalog into an externally verifiable, commercially exploitable asset portfolio. Which brings us to Section 4, why the Isle of Man? You might be wondering, why is a small crown dependency in the Irish Sea pioneering this massive global shift instead of, say, a major superpower? Well, the island actually combines a compact scale, which is perfect for deep industry collaboration, with a proven, rigorously executed regulatory framework. They have their own parliament, Tynwald, which gives them the legislative agility to move incredibly fast while still maintaining complete compatibility with UK common law. Plus, they already have a highly tested legal vehicle for asset holding via their Foundations Act of 2011, not to mention a seriously proven track record of regulatory innovation across both financial services and the digital economy. Honestly, it's the perfect testbed. Let's look at Section 5 to see how this plays out in a high-stakes use case, specifically healthcare AI. Across the entire healthcare sector, we see this exact same structural problem. AI innovation is completely bottlenecked. Health providers hold decades of longitudinal patient records, imaging archives, and treatment outcomes. It is an extraordinary goldmine for medical insight. But actually sharing it, that carries immense reputational and regulatory risk. When AI companies do manage to get access to multi-site data, it's almost always through these bespoke, fragmented agreements that take months, sometimes years, to negotiate, and they just cannot be replicated at scale.
As the quote here says perfectly, the missing piece isn't more data, it's governance that scales. By utilizing the Data Asset Foundations framework, healthcare providers can finally enable the secondary use of medical data for AI training and validation without transferring ownership or losing a drop of control. They don't have to expose themselves to the massive governance uncertainty that makes data sharing feel so terrifyingly risky today.
By giving data a clear legal identity, this framework completely solves the scalability problem. Consent suddenly becomes centralized and auditable, rather than being hopelessly fragmented across dozens of providers. Access is strictly controlled and purpose-limited. And the really cool part? The exact same structure works flawlessly whether one organization is involved or 20. This ensures everyone plays by the exact same rules, all while fiercely protecting patient trust and institutional integrity. Govern the data first. Let the AI follow. This brilliantly flips the conventional approach on its head. Usually, governance conversations in health AI focus almost entirely on auditing the AI model itself, preventing bias, maintaining accountability. But those questions are incredibly hard to answer if you don't first have rock-solid confidence in the underlying training data. By establishing clear boundaries, consistent consent handling, and a registered identity first, you build a reliable, evidence-based foundation for literally any AI tool to safely build upon. So, as global data governance inevitably tightens, the direction of travel is absolutely clear. The emergence of data as a formal legal asset class isn't just a theoretical shift anymore. It is unfolding right now, today. So the big question is, who will shape the infrastructure of responsible AI? Will you engage now and help influence the valuation models and standards the rest of the world will eventually adopt? Or will you be left scrambling to catch up to the organizations that are stepping up today? The race to own the 21st century's most valuable asset has officially begun. What's your next move?